Can I add my welcome to you all for this seventh lecture in honour of David Vaughan, and of course the first in which he's not sitting at this table in a bow tie, being self-deprecating, but as he said on some similar occasion, not too self-deprecating. My pleasant task tonight is to introduce our speaker, Judge Ian Forrester, but let me do so, at least start to do so, by bringing it back to David. You might think that a year since the last lecture in this series, and best part of a year since David died in January, that he wouldn't have known who this year's speaker was going to be. No one who knew David would think that he wouldn't have been interested to know or have strong views about that sort of thing, but in the circumstances he could have been forgiven for not actually knowing who the speaker would be. That, of course, would be to underestimate David most considerably. Last year we had an elegant paper from Marie Demetriou QC containing some closely argued views on the difficulty facing one of her regular clients, the CMA, in defending appeals before the Competition Appeal Tribunal. I remember the evening well. I had a lousy cold. I was ducking out of the drinks and sitting shivering in the Inner Temple room, wondering how one could counter the arguments that Marie had put forward so elegantly, and with which I disagreed pretty profoundly, down to the use of some definite articles. And I was wondering about that when, on his way, and glasses were clinking in the room behind, and on his way past, David stopped in front of me and he said, "We should line up Ian Forrester for next year." I nodded. Now, anyone who has ever worked with David will know what happened next. The 8 o'clock email the next day asking if I had invited Ian, the barrage of reminders over several weeks as to whether Ian had replied, whether he'd accepted, committed to a title, given us a date, and all that sort of thing. David had many fine qualities, and many of them are listed, beautifully summarized in David Anderson's tribute on the back of your, I won't call it service sheet, but the bit of paper you have. But no one would have called him correctly easygoing. I knew I had to land Ian. Liz knew it, Paul Gray knew it, and I'm pretty sure that Ian, and certainly his cabinet, knew it too. So here he is, quite probably the last David Vaughan lecturer to be identified and fervently requested by David. I'm not putting it more highly than quite probably. I would rule nothing out. Ian Forrester is the current judge of British nationality at the General Court in Luxembourg, and it seems really quite likely that he will be the last such occupant of that office. He's a member of the Faculty of Advocates, in other words, he's a Scottish barrister, and he was a devil, as they call them up there, pupil to us down here, to the first British member of the Court of First Instance, as it then was, Sir David Edward. So that's a nice, if rather unnecessary, bookending. Ian's extraordinarily successful career in practice can be summarized, if I may, as European with a US twist. He studied in the States as well as in Scotland and was admitted to the New York bar after taking them to court for attempting to exclude non-resident aliens from bar membership. These are skills we may need again. He worked for US firms at the beginning of his career in New York and then in Brussels, before setting up his own firm, Forrester and Naral, in 1981, which is when I first met him. They made a sensible decision and took in Brook Court's own Alistair Sutton in 1989, and then merged their very prestigious practice with White & Case in 1998. And White & Case have never looked back. Ian's practice is multifarious, with a strong portfolio of competition and dumping and trade cases, and he's appeared in many celebrated cases in Luxembourg. I was against him in one, the Microsoft case, where he had the glossy brief for Microsoft and I was for a scruffy trade association with the small recompense of actually winning. I remember three things about that, particular things for tonight about that case. One was helping Ian with his collar studs in the robing room before going out to do battle in the best traditions of the bar. Ian producing before the court a copy, it's possibly the copy, of the McGill Guide to wave before them. And at the end of a hard-fought week, watching rather enviously as the legions of Microsoft people headed off in minivans. You might not know this, but Microsoft took over the entire Sofitel Hotel in Luxembourg for the whole week. It was dry. They banned alcohol in the hotel. Jean-Francois Bellis told me it was miserable. Anyway, no doubt Ian had a little dram in his room. They were heading off to Ian's restored medieval, he says hovel, I dare say it's slightly larger than hovel, in Belgian Ardennes for a well-deserved party. And I understand that Ian has at that hovel what he describes as an aspiring but inchoate arboretum, some 2,000 trees of some 80 species. I observe this is perhaps a subtle example of nominative determinism. When not tending those trees, Ian is an elder at the Scottish Church of St Andrews in Brussels, quite an institution, as I can personally attest. His summons there have the same literary qualities, powerful argument and attention to detail as his many publications on competition law, where he was one of the leading voices in the debate towards modernisation of EU competition law. And it's characteristic of Ian, I would say, that one of his roles before taking up his appointment in Luxembourg was to be the head of White & Case's pro bono practice. He's a proud bencher of the Middle Temple, as all benchers of the Middle Temple should be. It's a powerful indication of how much David wanted Ian to give this lecture, that he was prepared to dangle the carrot of holding it here if that would tip the balance. So I'm delighted to be able to call on Ian to deliver this year's David Vaughan lecture.
Well, now, when David and I last chatted, we had a discussion about how things were going, and I offered my habitual claim to fame, which is that never in the history of the law has any lawyer seen his clients fined more than my clients. The astonishing number of 3 billion euros, which is really something pretty heroic, has sadly now been overtaken by a 4 billion fine on a single company as opposed to a number of successive companies. So my claim to distinction, always rather fragile, has become dented, and I am just a penal statistic of history. But even so, even though a statistic, to speak in such a gorgeous place and to speak of such a talented person and to speak on such a subject is an immense honour and pleasure. And to do so with so many friends from so many exotic corners of the world present, it just adds to that. Now, my theme, or my assigned title, is Advocacy, David Vaughan and European Courts, which permits me to say virtually anything. I'll begin by saying that when the UK joined the European Community in January 73, a number of things changed, and one of those won't change back. Now, in a technical and practical sense, we embarked on collective regulation with our European partners of many aspects of our daily lives, from air brake noise, feed for turkeys and calves, seatbelt anchorage points, equal pay, access to health care, extradition, pesticides, and the list goes on and on and on. In a less technical and sadly perpetually controversial sense, we embarked on a train destined for, well, on the label it says, an ever closer Europe. And, sad to say, we're currently the object of fascination and dismay as our friends and neighbours look on at political leaders seeking to reach the sunlit uplands of freedom from EU regulation without actually deregulating. Now, a little thought about dates. It's widely believed, and here I commend what James Flynn has said, it's widely believed that Brexit will happen on March 29th at 11 p.m. Greenwich time. Now, Bishop Ussher, with two S's, was a 17th century theologian, and along with other experts, he calculated that having studied closely the Bible's list of births and ages, ages at death, and other events, that God created the world with effect from 9 o'clock on Sunday the 23rd of October, 4004 BC. And the identification of each hour, each date, involved a lot of study of complex texts by experts. And each of the two dates, Brexit and Bishop Ussher's calculation of the date of the creation of the world by God, has been the subject of a bit of controversy. But each date has been accorded immense symbolic, iconic weight. Now, I suggest it would be spurious accuracy to say that on the 29th of March at 59 minutes to midnight, it would be spurious accuracy to say we shall be free of European law. More specifically for these proceedings, whether or not Brexit happens, one thing won't change, and that's the impact of members of the bar from the UK on the Court of Justice of the European Union and their effect upon European law. David Vaughan was a celebrity, a grand lawyer with a rich voice and a sumptuous presence, an enthusiasm for novel theories, no fear of judicial skepticism, no toleration of client nervousness, and an instinctive sense of humour. And there's dozens of David stories, and each has a favourite. But mine relates to Sunday trading, where David managed to, with others, to get a train rumbling round the magistrates' courts of England with numerous trips to Luxembourg. And he accurately described the challenge, this is now to the European Court, for B&Q, which was behind it all. On Sundays, B&Q could, well, if it chose, could lawfully sell pornography, but it couldn't sell Bibles. And he said, "My lords, it is well known that shops sell more when they are open than when they are closed." And delivered full volume and seductively, the message was very powerful. David and I were on opposite sides in the McGill case, which was a copyright case about the Radio Times and its Irish competitors, which came back to haunt us or to help us or not in the Microsoft case. And as you know, in Luxembourg, counsellor nicely called backstage before an argument to discuss the hearing and to answer any procedural questions that there might be. And so there's a big cluster of lawyers from different interests. And the president said, "Monsieur le juge rapporteur, reporting judge, do you have anything to say?" And the juge rapporteur, the reporting judge, said, "My lord, this is such an easy case that I don't think an argument is necessary." And Keats, in different circumstances, attributed to people silent on a Picandarian wild surmise, and that could characterize fairly what the lawyers felt when they looked at each other and shrugged, "What on earth does that mean?" So in that argument, David wanted to invoke an American precedent, or not, as I said, and he provoked wild guffaws when he stressed that he was absolutely ignorant on virtually everything in English law, but as a matter of American constitutional law, he was really pretty damned expert. And the judge, self-deprecating humor is very successful. And since he had invoked American law in reproaching the commission, I confess it was my client, for overreach, I felt emboldened to quote Robert Clive, who had been Viceroy of India, and he was under impeachment charges before the House of Lords about alleged corruption. And he defended his behaviour, and I adopted his words on behalf of the European Commission in saying, as did Clive, "My lords, I stand amazed at my own moderation." And at the end of the McGill argument, the Italian judge came in plain clothes, taking off his robe, back into the chamber and asked that I repeat the phrase, the context, and the reference. And David was watching regretfully. So it's a truth not universally acknowledged that judges like to be able to smile, and vivid expressions also give them pleasure. Now, that said, in the Fediol case, Judge Bosco, a trade unionist from Italy, formerly a trade unionist, then a judge, he was told by counsel that he would die laughing at a foolish argument of an adversary, and he replied rather chillily, not to say icily, that "La cour n'a pas besoin de rire," the court doesn't need to smile. Now, David was always ready to share ideas and pass on tips, and that in a profession which is endowed with a fair share of handsome egos is not a universal practice. But he counselled one young barrister faced in the factotum cases about fishing. He counselled one young chap who had the terrible, awe-inspiring task of appearing before Tasker Watkins, VC. Now, Tasker Watkins was the bar's great war hero with capital letters, and he was endowed with a personality of which any VC may properly be proud, and appearing before him with incendiary, inflammatory arguments about the non-primacy of English law was a daunting prospect. And David Vaughan said, "Get Milford Haven, where they have their investment and their tackle, into the first paragraph." And indeed, Milford Haven was volunteered, and Tasker Watkins, Victoria Cross holder, said benignly, "Oh yes, did you know that Lord Nelson was particularly fond of Milford Haven?" And things went better thereafter. Now, I've been asked to speak about the court and about advocacy there, and I could, of course, speak at great length on the need for clarity, simplicity, relevance, a touch of humour, a clear order of ideas, an edge of passion, and a focus on the essentials. Now, those are timeless requirements of the effective advocate. David had them absolutely in abundance. David's talent was in using those skills on a hitherto undeveloped legal landscape. And the Bar European Group, I was lunching today with Francis Jacobs, and according to Francis, at the first inaugural meeting, which David was a godfather of or progenitor of. Francis wasn't sure whether he and David constituted 1/4 of the audience or just 1/3, but it was a very skimpy group. And if we look around the numbers here present, one can see the phenomenal development of European law in that time. And who has, after assisting at a meeting of the Bar European group, especially the walk around the local vineyard, the tax-deductible brief talk about the law, and the brisk repairing to a delicious hostelry to sit under the vines and enjoy life and recollection of foolish judges and other things that lawyers talk about. So that's, in a sense, easy and familiar. Since I come from an unusual background, I'm going to share a few thoughts and experiences about the fascinating place where I sit. And I warn you, as did James, that my tenancy, my tenure, I should say, is a tiny bit precarious. So I often sign myself in frivolous notes to my colleagues in Luxembourg as Forrester, we speak French, Forrester le juge précaire, the wobbly judge. There were surprises when I arrived in Luxembourg. One was, I knew that the court had 24 official languages and 1 working language, but I didn't know how important that was. We deliberate in French, we draft in French, we send notes before deliberations in French. Now, translation, therefore, because we work out of French, but we produce judgments which are written in Lithuanian, Maltese, Irish, Latvian, or Finnish. Translation is an immense burden and, of course, a great richness. So the translation service at the court produces something like 1 million pages a year, and something like half, just a little under a half, of the staff of the European Court are engaged in translation. Now that has consequences for how cases are heard. Imagine about 43% of our cases are English, and 15-ish between French, Spanish, and German. The percentages vary from year to year, but that's roughly where we are. So 45 plus 3 times 15 plus a miscellany. So translating, if the case is in French, of course it goes quicker. If it's in a rather obscure language, by that I don't mean to be discourteous, but just to be accurate in saying that fewer people speak Lithuanian than speak French or German, the translation burden may become quite considerable. So a trademark appeal in Spanish, say, with say 40 pages and 10 annexes, that can take 6 weeks maybe to translate. So in a typical, not very big case, an exchange of pleadings, back and forth, 4 pleadings, can easily take 28 weeks. Now that doesn't mean that the judges go to sleep during that 28-week period, because if the appeal is in English, which everyone speaks, which everyone speaks with varying levels of comfort, or French or German, depending on the linguistic talents of the court, the judge can obviously get started while waiting for the translations to come back. Now, that's translation. Now, interpretation. Interpreters, if a hearing has been requested, will match to the language of the case the needs of the judicial formation. Now, I sit with judges from Denmark, Poland, Austria, and Italy, previously Lithuania and Cyprus, and Latvia. Now, depending on the language of the case, that will determine normally the nationality of the lawyers and the the preparations to be made for the argument. Now, in a good case, the interpretation is astonishingly good. It's absolutely seamless communication between bar and bench if the job of the advocate is well done. There's no miracle. A well-organized speech which has been planned well in advance, short sentences, appropriate speed, they all help to deliver to the judge a good abbreviated version of what counsel is saying. In other words, when it goes through interpretation, what the court hears is shorter than what counsel articulates. I have to say it's surprising how many counsel read at top speed the same self-points. And when that happens, we collectively breathe a sigh of relief, make an effort to understand what's being said, and we wish for an advocate of the caliber of David Vaughan. When a hearing is wasted by imperfect advocacy, the utility of the process is put in question. Why do you Brits bother? Why do we have to sit through this if we don't learn anything? So another, not a mistake, but something I hadn't realized prior to arriving in Luxembourg, is how much work has been done in the General Court in particular before the hearing takes place. And before the hearing, the judicial formation will always have discussed the merits. There will have been extensive communication in writing. Drafts have been going back and forth, and each of us normally will have a quite clear preliminary view. It might be, I'm not sure about admissibility, and I want to hear the parties on that, but commonly, not always, it will be a view as to the orientation that the chamber should follow. Now, I've also certainly attended hearings where we ended up at the end in a much different place than we expected to at the beginning. Now, a little bit about personalities and careers. It's been absolutely fascinating to sit in Luxembourg with people who have such extraordinarily different previous experiences. There have been, if we look back over the 70 years of the history of the European Court, 60 years I should say, some have been national career judges, others were professors, ministers, not of religion but of politics, civil servants, diplomats, one former head of state, one candidate unsuccessful to be head of state, 2 or 3 ex-soldiers, and at least one, a resistance hero. A relative minority were practitioners. Most of them, that's what I want to say, had spent maybe 30 years in their national hierarchy before coming to Luxembourg. So we are thus, the judges who sit in the courts in Luxembourg are more different. In other words, in every group, there's a bell curve of personality and experience shaped by history, by culture, by personality, and so on. So if you were to take 28 policemen in London, or 28 numismatists, or 28 ministers of religion, or 28 High Court judges, there would be a considerable commonality because of the shaping by professional experience and cultural traditions. Whereas we come to Luxembourg with 20 years teaching canon law in a university, or being a civil servant in the Ministry of Defence, or the Ministry of Foreign Affairs, or the Prime Minister's office. Those background effects are very strong and make for the diversity of personality that we have in Luxembourg. There's also a word to be said about the different notions of the function of the judge. Now, let's say the French civil law judge and the common law, let's say English judge. In the French constitutional model, judges are merely the mouthpiece that utters the legal principles already in existence, determining the outcome of a case. So far from being anecdotal or colourful, or even certainly gossipy, a French appellate judgment not so long ago might consist of one short, dense sentence, less than a page, maybe a bare paragraph. And by contrast, of course, a senior English or Irish or Scottish judge is commonly a former advocate, well paid, exotically dressed, enjoying great prestige, independence, and robustness. Now, as you well know, in England, Scotland, and Ireland, counsel and judges typically engage in public debate, and oral argument forms a big part of that, of the process of judicial determination. And questioning of the advocate, on occasion, as we all know here, especially here, questioning of the advocate can be something like a blood sport. And in my own jurisdiction of Scotland, 130 years ago, there was a particular bench that was known for ferocity and intemperance. And there's a report on constant interruption from and conversation upon the bench. The arguments of counsel were torn to tatters. This would happen. This would be a tornado which engulfed the pleader or laid him out limp. Several times counsel sat down and confessed themselves unable to plead because of the attitude of the bench, which seems inconsistent with what I have seen of Scots advocates. But anyway, and one often sees poor old counsel, like the early Christian, exposed in the arena to fight simultaneously with an elephant, a tiger, a leopard, and a bear. Now, in the civil law tradition, that's the shaggy wild northerners across the English Channel. In the continental tradition, counsel are usually heard in silence, at least when making their principal submissions. In our court, there is a reason for that silence, which I didn't realize. If a judge wants to put a point to counsel while the counsel is making a lengthy statement, maybe in German, if he's interrupted or she is interrupted, the interpreters may be at different points in the recording of that sentence, and therefore immense confusion can result. Anyway, our tradition is silence during the initial presentation by counsel. And after we sat one day, and after witnessing a robust hour, not an hour, maybe 5-7 minutes of vigorous debate, shall we call it, between myself and an English QC, who's also a good friend, one of my colleagues said to me afterwards, it's very interesting to see you and a barrister in a wig talking to each other. It's very interesting. And he's very polite, and I said, does it make you uncomfortable? I wouldn't wish to appear inappropriate in any way. And he said, no, I'm not uncomfortable, but if I did that in my jurisdiction, I would be subject to judicial discipline. So I continue to provoke and ask provocative questions, but it isn't in the continental tradition. It is in the continental tradition to ask questions which say, or which are of the nature of, on page 11, it's 42.5, but then on page 17, it looks as if you're saying 53, which is correct. That's the kind of question which my brethren from the civil law tradition are perfectly comfortable asking. But if it is challenging the argument put, that's not entirely, for some of them, that's not part of the tradition which is appropriate. Now, similarly, we can note that In the Anglo-American tradition, the identity of judges is well known. They might be somewhat celebrities. Chief Justice Marshall, Chief Justice Rehnquist, Chief Justice Warren or Berger and Lord Denning and others are well-known figures. But in the continental civilian tradition, although lawyers, of course, know the names of judges and their qualities, the wider public won't. And the dramas that we have seen, the wretched dramas that we have seen recently about the nomination of judges to the Supreme Court of the United States are very, very, very far away from the polite, private questioning by the 255 committee to which new nominees for the court are exposed. So, although the court may have, in England in particular, a celebrity status, its action is corporate and collegiate. So the civilian judge in Luxembourg will be accustomed to a cautious legal tradition of seeking identifiable errors of law and of addressing only those questions with which the court is properly seized. And I underestimated, before arriving in Luxembourg, the importance of framing arguments as actionable pleas in law. What is the legal error? What was wrong, legally speaking, for the institution to conclude that big ones and small ones fell into separate markets? So that tension between the civilian tradition and the necessity of identifying legal errors, and our duty in light of Menorini to the human rights case, which you're all familiar with, to do a review in principle complete of fact and law. That tension is a very stimulating and challenging one. I also underestimated the problem of prolixity, because we are frequently confronted with cases which are frequently, I won't say, on a number of occasions every year, we have cases where the decision at stake is 200 pages long, and the pleadings are 150 or 200 pages long. And that is a massive challenge just to digest what the essence of the case is. I don't have I regret that I don't have a solution as yet to offer. It's our duty to make careful review of legality in fact and law, and at the same time, the entity in competition cases whose actions we are examining will almost never have no legal basis for what it did. So that tension is perpetually of interest, and it's a challenge. Maybe I would add that the judgments that are produced in Luxembourg are somewhat diluted in collegiality and the traditions of producing a collective judgment, not a set of individual opinions. David Edward, my learned mentor, said that when I produced my first judgment, one of my colleagues said, "That's a very good opinion. Now we must make it a judgment. We must make it aseptic." The scope for individuality lies not in the public expression of one's own opinion, but in the development of personal relationships so as to be able to persuade others of one's point of view and to accommodate or reconcile different, divergent points of view. So, in most European countries, the judge's function is to come together to discuss and either unanimously or, if necessary, by a majority, decide how the case ought to be decided, and then to set out the reasons for that decision as objectively as possible. Judges don't write personal opinions. They participate in the collective writing of judgments, which are impersonal and objective. And as Sir David Edwards says, a bit surprisingly, I'm not sure I agree with him, a judgment ideally should be objective. Couldn't disagree with that. And he says, to an extent, unexciting. I'm trying to improve. There are no dissents in Luxembourg, as you know. There are in Strasbourg. Today, although in the past, sometimes there were cases where one of the judges sitting did not sign, today all members of the judicial formation sign, and the court tries to press on until the judges reach consensus in the form of a decision which is acceptable. And the minority and the majority work together to produce text which everyone is comfortable with, or sufficiently comfortable with, even if they're in the minority. The juge rapporteur, the person who is charged with drafting the judgment of the Chamber of Judges, may indeed be in the minority. So compromises can dilute the precision of the ruling, but there is only one ruling. And from time to time, though not very much these days in Luxembourg, there is discussion of the possibility of dissents. And the concern is that a dissent in a politically sensitive case might be jumped upon by a minister or an official or a government department to feel dispensed from the need to respect the judgment of the minority. Now, even if the identity of the dissenter were kept secret, the identified risk is that less weight would be attached to the majority judgment. One thing that the Strasbourg law, I think, is benefited by is that in Strasbourg cases, which are not like EU cases, but there are some similarities, big jerks in the law, big swings, big developments are maybe made smoother by the existence of a dissent, which says, yeah, maybe, but. And so it might be, for example, in the field of compulsory licenses in competition cases, where there have been big jumps from the McGill case through the Microsoft case and so on, it might have been that dissents would have played a useful part in helping the law develop smoothly. That's not a matter which is hot or cooking at the moment. Every court is interested in making its judgments as clear and intelligible as possible. And it's maybe interesting to note that it's appropriate for judges wearing an academic hat to write articles, not criticizing a judgment in which they've participated, but talking about their view of the law. And so the judge is not muzzled from pursuing an alternative view where the judge has been in the minority. Now, I think we're here talking about David Vaughan and in his honor, and we're talking about advocacy, and I'll just mention that European law has advanced, especially in the early days, thanks to the creativity and talent of good lawyers. Now, David Vaughan created ructions in several areas of the law, not always on the winning side, sometimes on the winning side. Factor tame, about fisheries, and many other things. Sunday trading. Stanley Adams, about a man who was wronged, he said, by the European Commission. Courage and Crehan, the long saga about beer. Now, in the early days, and I speak as someone with grey hair, there were great empty tracts of legal landscape. It was possible for knights to go riding out, looking for wrongs to right, to correct. And European law was a kind of savanna parkland with a few trees. Nowadays, it's a forest full of bushes and thickets and high trees and small trees, and dare I say it, don't quote me, some misshapen trees. And so I think it would be much more difficult for a new lawyer starting in a new area, unless he started in a new area, to make such a reputation as David did. Maybe Mr. Schrems, the data protection activist, is an example. But I want to mention just briefly 4 people who helped to shape the law. One of them is Luc Misson. Luc Misson, a Liège lawyer, first of all started on the law regarding persons when he defended 2 ladies of French nationality who were sitting in a bar in the red light district in Liège in windows, offering their services as sex workers in the same street as Belgian women doing the same task or activity. The Belgians were subject to a 100-franc fine, about €3, and the French were threatened with deportation. And Luc Misson took their case and was successful. He subsequently was successful in representing Mr. Jean-Marc Bosman, the footballer who, for good or ill, brought about a big change in the system of transferring players who were out of contract in a case involving UEFA, where I was also there. An example of how by being creative, you create new legal opportunities for your clients and you create a kind of slipstream. And that was Françoise Gravier, who wanted to study cartoon drawing in Liège. And she was charged a fee which only foreigners, non-Belgians, had to pay. And although the Treaty of Rome didn't deal with education, it was not unconnected, said Luc Misson, with community law. And so the European Court agreed that access to vocational training could fall within the scope of the EC Treaty. That was cartoon making. And then it was gunsmithing. And then it was being a vet. And then. So Luc Misson helped to develop the law, as did David, in the completely different field relating to persons. In England, Anthony Lester, my old colleague, Lord Lester of Herne Hill QC, had a series of cases on the subject of equal pay. And it started with MacArthur and Smith, where the question was whether male and female colleagues were not working in the same place at the same time in the same workplace. And that was a success, and that was followed by a case about Lloyds Bank and pensions, and then Jenkins and Kingsgate, where it was part-time and full-time. Anyway, cases selected to help develop the law in function of their facts. And my last example of the expansion of the law would be Savernin Lohman, the charming, old-school, elegant, well-dressed, courteous, fine gentleman from the Netherlands who had a client called Centre Farm, whose reputation was not as high as that of its lawyer. And Mr. Savernin Lohman said, if you do what I say, I can help change the law, which currently prevents you, a pharmaceutical wholesaler, buying in a cheap country, in those days the UK, and reselling in the Netherlands under the same brand, because it was possible for Roche UK to sell a product in the UK, and for Roche Netherlands to prevent the sale of that product in the UK on the grounds of a trademark infringement, not because the product was spurious, but because it was put on the market without the consent of the local Roche enterprise. So a corporate group could use trademark rights or patent rights to prevent cross-border trade. And de Savernin Lohman helped develop the court's case law, so that it was possible to separate spurious goods on the one hand from genuine but commercially unwelcome imports. Now, David made new law in lots of fields. One I didn't mention, and which I should, because it relates specifically to competition, was the ICI saga. And how to reconcile the penal, quasi-penal, quasi-criminal features of competition law with the administrative nature of the Commission's procedures. So David wasn't unique in finding and tending a legal vine and making it flourish and produce grapes which all could enjoy. But David was exceptional in that his vines made a Grand Cru vineyard, which has immensely benefited the English bar. Now, I'm coming to an end. David Vaughan's career was focused on the novel, potent, fascinating, open, obscure field of European law. He, like the few others of his generation, owed much to the opportunity offered professionally by the new quasi-constitutional legal principles which are drawn up in the Treaty of Rome. An economic constitution which spoke with the monumental brevity of constitutions. Those who started their careers then were lucky. Each judgment from the court was a novelty to be carefully analysed. A case about a girl who was an au pair and she didn't sign on properly at the local commune, and somehow that got referred. Watson and Bellman, we read that, and we tried to squeeze all possible juice out of it. Our career, David's career, was centred on the European adventure. He helped create great swathes of new doctrine, and others here shared in that exciting expansion, sometimes on the winning side, sometimes not. And his practice flourished, as did those in his slipstream. He saw opportunity, he encouraged, he achieved great things and took pleasure in the success of others. Now, of course, there was a political component as well as technical legal ones, but this bar flourished and thrived there. It would be comfortable here to stop and to raise a toast in honour of a great advocate, a splendid, fun, larger-than-life, engaging, charming figure. But I can't refrain from commenting on the times in which we live. David died before Brexit reached its current depths. I quote, and I am pained to quote, the following words from a British public figure who wrote, "When a community is going through some period of stress, they are historically far more likely to turn on scapegoats in their midst. Anxiety is transferred to some readily identifiable group: Jews, foreigners, homosexuals, gypsies. They become a catch-all explanation for everything that's gone wrong. Your kids can't get a house? It's the immigrants. Can't get a job? It's the immigrants. Can't see a doctor in A&E? It's the immigrants. People are only too willing to project their anger onto a particular group, and some politicians, alas, are only too willing to assist." That was written by Boris Johnson. Archbishop of Canterbury, Justin Welby, spoke around the same time of cracks in the thin crust of politeness and tolerance of our society, through which since the referendum we have seen an outwelling of poison and hatred that I cannot remember in this country for very many years. It is inequality that thins out the crust of our society and raises the level of anger, resentment, and bitterness. The tools for tackling inequality are readily available. The obvious ones: education, public health, mental health, and housing. I sometimes fear these days that England has lost, for the moment at least, the welcome and the tolerance for which it was famous and to which strangers were accustomed. Over 4 million people outside their country of citizenship today find themselves in a state of limbo. A moving book called In Limbo has just been published, recording the ordinary testimony of ordinary folk confronted with unpleasant, distressing, painful, hideous experiences. One woman, she's Greek, she's on the subway, her sister calls, this is shortly after the referendum, her sister calls from Athens to discuss their father's funeral, and they speak, and the man sitting across from her looks agitated, and she continues speaking, and she finally stops the conversation, and the man across from her says, we voted to get rid of you, go back to Poland. Now, such episodes, sadly, are not at all uncommon. And so that book well tells the ordinary people's distress and uncertainty at being confronted with being legally vulnerable, being aliens, and being administratively at risk. Now, the challenge of being an alien, even in a non-authoritarian democracy, is real. The Windrush episode should make us, the privileged, blush. Skepticism about foreigners is worst for the poor, the inarticulate, the minority, the unconfident. Now, universities, restaurants, the Inns of Court, technology companies, hospitals, hotels, fruit farmers, engineers, they want to recruit the best and the brightest. And yet, immigrants, strangers, foreigners who have been living in this country have been leaving due to verbal abuse in the street and prescriptive, detailed regulation which comes close to hostility. And I suggest that we not lose sight of the principle that the public authority must treat the unrepresented weak with decency and with fairness. And there's another principle which deserves to be recollected, and that is the principle of the rule of law and the rule of courts. And I'll burden you with another quotation, this time last month, from Lord Neuberger, the former president of the Supreme Court, speaking with the freedom of having laid down his office. He said, "In the woeful litany of ignorance which have bedeviled the public debate about the UK's membership of the European Union, no topic has been the subject of more misconception and prejudice than the Court of Justice. The general objection to the Court that it represents an interference with UK's sovereignty does no more than restate the objection to the UK being a member of the EU. It's inherent in and fundamental to the whole concept that it will have rules which all members must obey. And if there are such rules, there has to be a supranational body which definitively interprets those rules to ensure consistency of application across all member states." It's a lovely idea to celebrate a great advocate and to do so in a building which has served to deliver fun and learning to lawyers and students and old lawyers for nearly 500 years. But I think that this gathering, honouring David and his contribution to European law, cannot not note the barely imaginable threat which now confronts that law and the infrastructures of our daily lives which they support. So, while remembering David Vaughan, CBE, QC, legal titan, creative wizard, let's also add a word that he would endorse. We should know that geography compels cooperation. We should know and we should state that Brexit is not as easy as resigning from a golf club. We should have learned from history that badly drafted legislation and unrealistic treaties might not survive crises or practical problems. Winning, beating the enemy, should not be the goal. So, in these critical days, I hope we should encourage others and ourselves to calm down, breathe deeply, refrain from mocking or cheap accusation of bad faith. We should reproach zealots, and we should encourage sensible discourse and hope for a rational outcome. And I think David Vaughan would cheer for that proposition. Thank you.